All right, welcome back. As we do every Wednesday night, we bring in our legal panel in here to talk about a few issues. So let's go around the table. Jim Kasouras, he a criminal defense attorney in Manhattan, lectures at New York Law School, visiting professor at the University of Birmingham in England. Doug Von Oist, founding partner of Karsten Von Oist, focusing on corporate misconduct, and was selected by the Legal 500 as one of the most influential trial lawyers in the nation. And Mark Furnish, constitutional attorney, who's argued before the highest court in the land and is a professor at Brooklyn Law to boot. All right, guys, first up, that partial verdict in the so-called loud music murder trial in Florida. It seemed like everything is in Florida. Michael Dunn, convicted of second-degree murder, but the jury was deadlocked on charges of murder in the first degree. And what's more, jurors who are now talking say they knew from day one of deliberations it would end up with a hung jury.
I believed he was guilty. We pretty much knew after about 2 days with that whole self-defense thing that we were going to be hung. We all agreed that there was an imminent threat to these young men that were in the car.
Okay, I got a few questions on this. I'll start with the obvious, but then maybe with some that isn't as much. Is it that the law is so confusing and people don't know what stand your ground or self-defense means in the state of Florida? If you're in a car and you play loud music, is it enough for a person to say, I mean, let's be honest, they got convicted, he got convicted because the other three guys in the car got shot, not the guy who was killed. That's not why he's going to serve 60 years. So the first question I have is it just the law that's confusing, or is it something else?
I don't think it's confusing. And what happened here was it was 9-3 for conviction on the murder. So there's really nothing very confusing about it. 3 jurors were not convinced beyond a reasonable doubt that he didn't see a barrel of a gun. He said he saw a barrel of a gun. So he basically confessed to the 3 charges for which he was convicted. The car was driving away and he was shooting at it like a wild man. But there were 3 jurors who weren't convinced beyond a reasonable doubt that he didn't see the barrel of a gun. So I don't think that this jury instructions can be very complicated.
Yeah, and I want to get into that in a second. But in this particular case, do we hang it on, stand your ground, that as long as you think, you believe there's a threat to you, that somehow mitigates you opening fire on 4 defenseless teenagers?
Well, it's not a stand your ground case because they didn't invoke
self-defense, I guess.
Well,
yes.
Self-defense, no. The answer to your question with reference to self-defense is no, because the fear, you not only have to subjectively feel the fear, but it has to be a fear that society would find reasonable, an objectively reasonable fear. So that's where the rub is in these cases, because anybody can get up on the stand and say, oh, I was afraid. The real question is, well, was it reasonable for you to be afraid in that circumstance? And I would say, no, it's not reasonable for you to be afraid to the degree where you're, pumping 10 shots into the car.
And every other, Mark, contributing piece of testimony from his own fiancée, who said, when I went to get out of the car to go in the store, he was already complaining about the music and those people and everything else. And Doug, the one commonality out of all these cases is Florida and a white guy and a black victim, and you don't even, that's not fair about the movie theater, I grant you, but Florida, people with gun here, maybe too much sun, I don't know what's going on, but it does strain the mind that somebody thinks it was justifiable. It's all the hanging chads. That you see something or hear something you don't like, your first instinct is to grab for the gun.
Well, listen, I mean, it almost seems like a cultural thing. If you let people have guns and you put them in situations, I mean, the question that you're not talking about with Dunn is he came from a wedding. I don't know if they could look into whether the guy was intoxicated at the time. And it goes to what's reasonable, exactly what you were saying. Listen, one juror could say that's reasonable to me, and another juror would say that's completely unreasonable. And maybe that's the problem they had in that jury room.
And at least in the Zimmerman case, he could show he had a broken nose and a bloody face. The guy went over to, where was it? I forget, he went afterwards. He had more drinks, never reported the shooting, never did anything after the fact. His own fiancée contradicted his own story. None of his expert witnesses could even testify at trial. This one boggles my mind.
It sounds like a compromise. It sounds like 3 people did not want to do what they were supposed to do, and they took the easy way out and said, I'm not going to vote guilty, so they hung on that. And it sounds like a compromise to me where it's convict them of what we have to convict them on.
Okay, well, then that comes back to a couple issues. First for me is, okay, The argument I've heard, Mark, is, hey, the guy's going to get 60 years anyway. He's never going to see the light of day. What's the point in retrying this, even if we don't think justice was served? The opposition argument is justice, even when it's not convenient. Where do you fall?
Well, let's not jump to any conclusions and be so sure that there is going to be a retrial. Any number of things could happen. It's quite natural and appropriate for the prosecutor to come out and say, oh, we're going to retry it, we're going to retry it tomorrow.
Do you think there should be one?
No, I don't think that there should be one because it's not practical. It would have symbolic value, as you intimate. If he gets convicted, same thing could happen again. But right now, the guy's looking at 75 years. So it's a de facto life sentence. And I think it's a waste of time and a waste of money. It's a compromise. I agree with what Jimmy said, and the result is the same regardless.
But what about the messaging that you can't murder somebody and not call it that?
Clearly, that is one of the reasons why you would want to retry the case.
Would you want it retried?
Symbolically, I would want it retried, but you have to really think about it both ways. You know, it isn't practical. He's getting 60 years as a mandatory minimum, and why take the risk that the same thing happens again and you're going through this again and again and again? It's a very tough question. I mean, the bigger question is, what if you don't have those other shots and you don't have those other people? And so you don't have this conviction for, you know, him shooting at a car running
that was
away.
my point.
And now you've got a hung jury and he's not doing any time unless you try it again.
But you know, they're also trying to figure out this law, and I hate to say it, but this jury wasn't clear. Maybe the judge, the instruction wasn't clear. I mean, you almost have to try this again just to figure out what happened and whether it applies. The legislature may have to look at this. There's problems
Well,
here.
speak to jury instruction, because this is the part that I'm curious from you guys. Take this case out of it. How many times have you sat in a courtroom? You've heard from the witnesses, you've seen the evidence, you've heard from the testimony from everybody, and now the judge instructs the jury. Have you ever been in a circumstance where you said, oh, well, that seals it, or what's he doing? How important, A, is jury instruction, and how much does it really shape, in many ways, the verdict here?
I mean, I think it depends upon the jury, but listen, as lawyers, we pick up on stuff when we're listening right along with everybody else, what the judge is reading, and we're thinking, oh, that's important. We don't really know what the jury is thinking. I mean, there's a lot of legal information thrown at a jury all at once. You know, it depends upon the jury, it depends upon the instruction, but what I can tell you is the judge can't vary from that instruction. If he does, he'll have a problem, you know, on an appeal.
Which is a problem because when a jury comes back and says, can you explain this, judges are so worried that if they vary at all from the written word of the jury instruction, they're going to get reversed. So very, very often you have a judge saying, well, I'm just going to repeat the charge. What we do as lawyers very often is you look at the charge. Always look at the jury charge before you start trying the case, because there are words in there you want to have in your presentation because they're going to resonate with the jury at the end of the day. But if a jury doesn't understand the instructions, quite often they're not getting any help.
And Mark, is it boilerplate or is it discretionary how the judge instructs the jury?
Well, it's often a point of contention among the two sides in the case. It depends on the case, whether it's boilerplate or whether you need instructions that are uniquely tailored to the facts of the case.
And when does that get decided?
Well, you start litigating that before the case even begins. You submit requests to charge to the judge, and the parties fight about it. In some cases, it's pretty rote. In some cases, it can be dispositive, particularly in what I do. I make my living off these jury charges as an appeals lawyer. But to get back very quickly to your question, in my experience, juries do struggle and try hard to follow the letter of the law and decipher the instructions and apply them faithfully. But they have the power, if not the right, to nullify, to go against the instructions and achieve what amounts to a sense of rough justice despite the instructions. Now, it seems to me that this case in Florida is a textbook case of intentional murder under the letter of the law. But as a matter of common sense, this guy didn't go in there intending for this to happen. It was an impromptu event that spiraled out of control. Under the letter of the law, he probably should have been convicted of intentional murder. But as a matter of intuitively or viscerally, this was just a bad situation that spiraled out of control, and I agree. They reached a compromise to try to reflect that reality.
Okay, when we come back, we're going to get a little closer to home. Christie aides, they said that they will not cooperate with the subpoenas from Trenton. I'm going to have the table explain to me what that means and also what happens next here, who can force who to talk here or at least face contempt charges. Stay with us.